to 1949, and John Quigley's The Case for Palestine, an International Law Perspective. I build on these texts by scrutinizing Israel's legal and political strategy following the 1967 war, analyzing the Palestine Liberation Organization's legal advocacy at the United Nations during the 1970s, tracing the peace talks in Madrid, Washington and Oslo between 1991 and 1993, and examining how Israel's legal interventions shifted the legal framework from occupation to warfare between 2001 and 2017. The formative literature on international law and the question of Palestine also includes the essays in Beyond Occupation, Apartheid, Colonialism, and International Law in the Occupied Palestinian Territories, edited by Virginia Tilley, and International Law and the Israeli-Palestinian Conflict, a rights-based approach to Middle East peace, edited by Susan M. Akram, Michael Dumper, Michael Link, and Ian Scobby. These texts pay meticulous attention to the law, either to advance a legal argument or to suggest practical approaches for resolving the conflict. The works of George Bisharat, Palestinian Lawyers and Israeli Rule, Law and Disorder in the West Bank, and Lisa Hajar, Courting Conflict, the Israeli military court system in the West Bank and Gaza, examine how Israel's legal regimes and Palestinian legal advocacy have shaped Palestinian subjectivity and social life. They highlight the simultaneous durability and vulnerability of Israeli structures of domination over Palestinians. This book does not advance legal prescriptions, nor make exhaustive legal arguments. It reveals how the law is working during consequential historical moments. It shows how the law's ability to oppress is evidence not of its failure, but rather of the fact that it can be strategically deployed. This cynicism about the law is also found in Volume 4 of Raja Shahadi's From Occupation to Interim Accords, Israel and the Palestinian Territories, which traces Israel's deployment of law to successfully consolidate its land takings and sanctify its system of domination in the negotiated peace agreement between Israel and the Palestine Liberation Organization, PLO. More recent titles, such as Laurie Allen's The Rise and Fall of Human Rights, Cynicism and Politics in Occupied Palestine, and Neve Gordon and Nicola Perugini's The Human Right to Dominate, similarly examine the limitations of human rights law and the risks posed by invoking it. Finally, Justice for Some benefits from researchers' resurgent use of a settler colonial framework to understand the question of Palestine. The return of this analytical approach has made it possible for this book to delve into the settler colonial nature of the Palestinian struggle. Ongoing struggles in the United States, Canada, Hawaii, and Australia also offer instructive lessons on decolonization. Similarly, US-based movements protesting state violence and the dehumanization of black communities, in particular, inform my optimism. Among the many lessons that black radical protest and knowledge production have offered is that there is no return to an optimal past. There are only optimal futures to shape. While I build on and advance a skeptical analysis of the law's utility, I am not pessimistic. Change is possible. Our present is the culmination.